respected judge, esteemed faculty members, and my dear participants. A very good morning to everyone. It is my privilege to welcome you all to the national level Constituent Assembly debate competition.
Ajay, listen to me. Ajay here, this side IT host. Wait for some moment. I'll let you know once we go live, and I'll make the start the recording. Wait for some moment.
For sure, sir, definitely. For seminar only the participants.
Ajay, Ajay, you can start now. Ajay, we are on live. You can start now.
Ma'am, with your permission, can we start?
Yes, please proceed.
Respected judge, esteemed faculty members, and my dear participants. A very good morning to everyone. It is my privilege to welcome you all to the national level Constituent Assembly debate competition organized by MIT Law School, MIT University, Madhya Pradesh. Today we have gathered not merely for a competition, but for a meaningful engagement with the very principles that shape our constitution and democratic framework. We are overwhelmed with the presence of esteemed panelist Ms. Nidhi Kaswar, who spare her valuable time for judging the preliminary round. The topic for today's deliberation is whether the judiciary should have the power of judicial review or not. It is a both timeless and highly relevant. It reflects the question that has been central to constitutional governance, the balance of power between the legislature, executive, and judiciary. Before we begin, I would like to briefly outline the rules and structure of the competition. All the speakers shall be required to mention their participant code strictly that at the time of the competition. All the participants are also requested to kindly modify their name in the line of CADC and allotted code. Each participant shall be given 8 minutes to present their arguments. A warning bell will be ring given 1 minute before the conclusion of the time. Participants are expected to maintain decorum and adhere to strictly to allotted time. Rebuttals should be concise and respectful and shall be of 2 minutes. The decision of the judge shall be final and binding. I request all the participants to present their arguments with clarity, confidence, and respect, opposing views, keeping in mind the essence of democratic discourse. With the permission of ma'am, I would like to just tally the participants' works.
Yes, please.
So ma'am, I'll be calling the participant code, and if you can see, do you have the list of those participants? And all the participants are requested to kindly raise their hands once their name is being called out. So we have CADC 19 against the motion.
Hello.
CADC 19. CADC 19 for against the motion.
I am present.
Okay. CADC 20 for the motion.
Yes, sir. I am present. I am
Okay.
for the motion.
CADC. Okay. CADC 21 for against the motion.
Yes, sir. I am present.
Okay. CADC 22 for the motion. CADC 22 for the motion. CADC
Present, sir.
23. Okay. CADC 23 against the motion.
Present, sir.
CADC 24 for the motion. CADC 24 for the motion. CADC 24 for the motion. CADC 25 against the motion. CADC 25 against the motion.
Yes, sir.
Okay. CADC 26 for the motion.
Present, sir.
CAD, okay. CADC 27 against the motion. CADC 27 against the motion. CADC 27 for against the motion. CADC 28. CADC 29 against the motion.
Present, sir.
CADC 29 against the motion.
Present, sir.
Okay. CADC 30 for the motion.
Present.
CADC 31 against the motion. CADC 31 against the motion. CADC 32 for the motion.
Yeah, present.
CADC 33 for the against the motion.
Present.
CADC 34 for the motion.
Present, sir.
CADC 35 against the motion. CADC 35 against the motion. CADC 36 for the motion. CADC 36 for the motion. Okay. So with the permission of the honorable judge, we would like to start a session, ma'am.
Yes, please proceed.
So first of all, I would like to call CADC 19 and CADC 20 for, respectively against the motion and for the motion.
This is 19 present.
Okay. So I have made you the co-host. You can start your deliberations.
Sir, 20 also present.
Okay, ma'am. I have also made you the co-host.
Sir, shall the opposition start first or the supporting start first?
CADC 20, you need to start your deliberation for the motion. CADC 20.
Yes, sir. Sir, may I start? Sir, may I start? Proceed.
Yes, ma'am. Please proceed.
Okay. In any game, the umpire's role is to ensure that the rules are upheld, not to dictate the course of play. When this line of separation begins to blur, the fairness of the game itself comes into question. It is this principle of limits, balance, and institutional responsibility that lies at the heart of the very issue we are discussing today. Esteemed judges, distinguished members of the House, and my fellow debaters, for a moment I want you to step beyond abstract constitutional theories and confront the reality of power and practice. Imagine a law enacted with overwhelming public mandate, yet one that subtly erodes fundamental rights, stifles dissent, or even marginalizes an entire section of society. In such moments, majoritarianism cannot be the ultimate safeguard. There must exist an independent constitutional conscience, one that stands above political expediency and speaks for justice when the majority falls silent. And it's precisely for this reason that I stand before you today firmly in favor of the motion that the judiciary should have the power of judicial review, because this power does not transform judges into rulers of the people. It entrusts them with an even higher duty to act as the guardians of the Constitution and steadfast defenders of liberty. Let me clarify at the very outset, this is not about elevating the power of the judiciary. Its function is not dominance, but constitutional guardianship. The real question before us is that a democracy can truly endure without such an institution capable of serving as a check on its power. जहाँ शक्ति संतुलित रहती है, वहीं लोकतंत्र सुरक्षित रहता है, और इसी संतुलन को बनाए रखने के लिए न्यायिक समीक्षा यानी जुडिशियल रिव्यू आवश्यक है. At its core, this debate is about the limits of power and protection of rights. Because democracy is not merely about the rule of the majority, it is about the preservation of constitutional morality, where even the smallest voice is heard against the might of the many. And this is where judicial review becomes indispensable. It ensures that legality prevails over popularity and that constitutional values prevail over political convenience. It is often said that this constitution gives courts the power to review laws, and rightly so. Draft articles 8, 25, the heart and soul of the constitution, and 202 are not insignificant provisions within this document. They are deliberate safeguards placed to ensure that fundamental rights remain protected against any possible misuse of power, because a constitution cannot depend solely on the goodwill of those in authority. Rights hold value only when citizens possess the means to enforce them and when courts possess the authority to defend them. Judicial review is not a sign of judicial dominance, it is a constitutional safeguard intended to ensure that no law and no institution stands above the Constitution itself. What we are creating today is not merely a legal power, but a constitutional safeguard meant to protect the spirit of this republic. Judicial review ensures that no authority and no temporary majority can rise above the Constitution. We've already witnessed under colonial rule what happens when authority goes unchecked. Independent India cannot afford to repeat that mistake. That is why courts must have the authority to ensure that laws remain within constitutional limits, not to dominate parliament, but to ensure that rights and liberties are never sacrificed for political convenience. Yes, in a democracy, accountability is important. Elected representatives answer to the people, but judges answer to the constitution itself. Its duty is not to follow political pressure, but to uphold law, reason, and constitutional principles. Judges are not elected, and that is what allows them to stay independent and protect rights without political pressure. What may appear to some as judicial interference is often the judiciary performing its constitutional duty, stepping in when power exceeds its limits or when rights are placed at risk. Because if someday the rights of citizens are threatened, this republic must contain an institution capable of standing between the power and its people, ensuring that legislature and the executive power never becomes unchecked. As Lord Acton famously warned, power tends to corrupt, and absolute power corrupts absolutely. Judicial review exists solely to prevent such concentration of unchecked authority. A democracy remains strong not when its power is concentrated, but when its power is balanced, limited, and constantly subject to constitutional restraint. And that balance is exactly what judicial review seeks to preserve. In conclusion, the real question before us is not whether judicial review grants power to the judiciary, but whether this constitution can truly protect liberty without it. A democracy is not measured merely by the strength of its government, but by the security of rights granted to its citizens. Judicial review ensures that the Constitution remains supreme, that freedoms remain protected, and that no authority ever becomes absolute. Because democracy is not about giving power to the people, but ensuring that power is never used against them. And if someday the rights of citizens are threatened, this republic must never be left in a position where the government can do nothing but remain silent. Dharmo rakshati rakshitah. Those who protect justice are themselves protected by it, and perhaps that is exactly what judicial review seeks to ensure. Thank you so much. Jai Hind, Jai Bharat.
CADC 19, you may start the session.
May I start, sir? As Charles Evans Hughes rightly said, we are under a constitution, but the constitution is what the judges say it is. Respected judges, honorable members, and everyone who are present over here, I stand before you to oppose the motion that the judiciary should have the exceeded power of judicial review. Honorable members, today the debate is not just about the judiciary, it is a debate for our democracy. Let me begin by making one thing very clear. The judicial review per se, or judicial review which was initially intended to, was never wrong. But the issue is not just its existence, the issue is its expansion, the issue is its misuse. Judicial review is a safeguard which ensures that the constitution evolves into a mechanism for the democratic society along with the changing dynamics of the society. But today, as the day goes on, it is turning into a mechanism which overrides the democratic will of the people. When a power which is meant to interpret, when a power which is meant to control or check begins to invalidate, begins to cross boundaries, we must ask ourselves, are we really preserving democracy or are we slowly replacing it as a whole? The core of the debate lies in three, four main doctrines. The first, the doctrines of democracy, popular sovereignty, and most importantly, the separation of powers. In a democracy, as we all know, it is a very well established fact that the power flows from the people. The people elect the representatives themselves. Laws are made and enacted by these elected representatives. But if at all judicial review is allowed to expand, the very power, the very authority is given to the unelected judges who overturn these laws gradually. First of all, the judiciary always focuses on the principle of separation of powers, but the judiciary itself meddles with other two organs. The separation of powers cannot be one way principle. It should be applied on a whole, it should be taken into consideration as a whole. Judicial review risks this very own doctrine of separation of powers into a doctrine of judicial dominance. Judiciary is very important, that is a non negotiable thing. But the problem arises when the judiciary turns slowly into a judicial dominance. The judiciary strongly advocates that the legislature and executive must maintain the boundaries. But when judicial review crosses the boundaries, the very self contradiction is very viable in this nature. The judicial review often turns into judicial activism and judicial overreach in multiple cases, Your Lordship. What begins as a social or a judicial review, it often ends as a judicial supremacy. As we all know, no one is supreme, and the Constitution is the supreme law of our country. Judges, we do understand that the judges are very learned persons in the field of law. But when it comes to the points of economics, when it comes to points of governance or public administration, the court or the judiciary is not the appropriate authority that we look up to. The electoral accountability, the actual legitimacy which was dealt by the people is what is of the utmost importance in this regard. As we all know, the NJAC case, in the case of Supreme Court Advocates on Record Association, was the Union of India. The Parliament in the states attempted to reform a judicial appointment through NJAC. The Honorable Judiciary unequivocally restricted this, unequivocally invalidated this by upholding the collegium system in the first place. So we rightly understood, or we can rightly infer that where there is a reform which is about to take place in the judiciary strictly invalidates, the judiciary strictly opposes. That is where judicial review turns into judicial activism in the first place. Also, there are many cases such as the 2G spectrum case, which says that where the central bills are necessary for the governance, the court often declares them as invalidated or unconstitutional. When we take it the international perspective, in the R. Miller versus Prime Minister, it is a landmark case of the United Kingdom's ASAF, where the judiciary was constantly interfering in a political decision, but it was upheld that the political decision should be free from any external pressures in the first place. And moreover, in a country as vast as India, in a country as diverse and as populated as India, judiciary is already overburdened with hundreds and thousands of cases. Hundreds of people, thousands of people are already waiting for justice, already fighting the injustice that we are facing. By further relying upon the judiciary for the laws, for the acts, for the bills, we are further overburdening and delaying the justice in the first place. When the judicial review transforms governance into a litigation, the litigation turns into a delay as such. When we are transforming a good legislation or a good act into a form of litigation in the courts as of a personal matter or such, it stays there without any giving justice to the people of India. Justice delayed is justice denied, and judicial review often contributes to this delay. The judiciary often faces with the questions of law, often faces with the interpretations of law. By further burdening, by further indicating these laws or attributing these powers to judiciary, we are overburdening and delaying the justice. And even after years of litigation, even after years of inconsistentness, there is no guarantee that the judicial review will ever resolve this issue conclusively. And most importantly, the question might arise in one single question. If not judicial review, then what actually checks the parliamentary power? There are many measures which are given by our respectable and Constitution of India. Firstly, the very legislature which has introduced a bill can amend, can repeal the laws. Secondly, the electoral accountability. As India, we follow democracy, we follow the voting system, we follow the will of the people. We must always respect the very will of the people. By if at all any law, if at all anything is overturned, if at all it is anything over the people are always ready to retaliate, ready to revolt, and to advise the government of what it should do correctly. And executive checks, when a parliament, as the opposition may contend that the opposition takes the full power as such, we in a parliament where there is a ruling party, there is even an opposition party. Also, we have governors and president of India in order to check whether the law is valid or not. Most importantly, we have free press and a civil society, which ensures that every law, everything which is done by the parliament is up to the constitutional mandates. In conclusion, though it was initially intended as a safeguard, day to day the judicial review is interfering in the other spheres and other domains. If at all in some situations judicial restraint is followed, then the justice would be more appropriate, then the functions of both the houses and the organs of the government will function more smoothly. Finally, democracy is not about the perfect decisions. It is about the decisions which are made by the people, and power must remain with the people who are accountable. Thank you, honorable members.
CAGC 20, do you like to exercise your rebuttal? CAGC 20, would you like to exercise your rebuttal?
Yes, sir.
You may start your rebuttal.
Yes, sir. So, first of all, yesterday, I would like to acknowledge the judges. Yesterday, when we were in the orientation session, we were strictly told to follow the timeline of 1946 to 1951. We were told this yesterday in the orientation, and CADC 19 has used the cases 2G spectrum and one more case which does not adhere to the timeline 1946 to 1951, and I think that is a violation of the rules of the committee. And also, my questions to CADC 19 is, even if the judiciary expands judicial even if judicial review expands judicial role, it is not the expansion of power, it is the protection of the constitution, and without it parliament or the executive could pass any law without check, which is far more dangerous. If no one checks on law, who will stop unconstitutional decisions? Also, judicial review is actually what protects democracy. It does not weaken it. Democracy is not just majority rule, it is also the rule of law and protection of rights. So, judicial review is guard of citizen rights, not enemy of democracy. And if we remove judicial review completely, it would be like removing brakes from a car because sometimes they are used too much. How are you saying that judicial review is not preserving the democracy, or it is like it is not preserving the democracy and it is expanding power? It's not expanding its power, it's about protection of the rights. If no one will protect, then who will? If judiciary won't, then who will? That's all. Thank you.
May I answer?
Yes, please, you may start.
Honorable jury, with utmost respect, pertaining to the time limit of the cases which the honorable opposition has tabled, I would like to humbly submit one simple thing, that I started. We started the debate saying that the judicial review per se was not wrong, but its over expansion in the present day-to-day life is what is being wrong. We understand the time limit was set from 1947 to 51, but I place a reliance on the recent cases as how the judicial review transforms over time. Where the judicial review was originally intended to just review the cases, the judicial review has turned actively into a judicial activism kind of state, where where the parliament intends to bring any changes in the judiciary itself. The judiciary unequivocally invalidates such provisions or such acts with such changes. That is the mere reason why I have mentioned about the recent 2G spectrum case or NJAC case. That is just an example of how judicial review in the long run affects the people and affects the judiciary also. Secondly, when we come into accountability, we understand the honorable learned member from the supporting side has said that if not democracy, then who will be accountable in the first place? I would like to contend that if at all, if the people or the elected representatives are not held to be accountable, the judges who are not elected by anyone, then who exactly will the judges be accountable for? At the end of the day, we have to see that the constitution is the constitution is the supreme law of the country. If at all judiciary is expanded its wings in order to interpret everything in its insane sense, then what exactly are the courts being accountable for? Secondly, we have to think of in a practical way. as we have already mentioned, that India being a diverse country, India being a huge
Time has
country.
stopped. Okay, from exceeded or time. Now I would like to request CADC 22 and CADC 21 to start the session.
Present, sir.
Sir, before starting, actually, there's a small problem that the internet connection has been too weak in this building.
Well, you may start.
Uh,
CADC 22, you're not audible. Well, due to the network issue, we would be skipping the CADC 22
so,
and 21. We'll be continuing
yes,
them
sir, I will.
at
Sir,
the
am
end
I
of the
audible
session.
properly?
Yes, you are not now audible. You may start your session. CADC 22, you may start the session.
So should I start?
CADC 22, you may start the session. Well, in case of his, due to his unavailability, we will be proceeding with a CADC 21 for against the motion.
Thank you, sir. First of all, with my heartfelt greetings to respected bench and all dignitaries who present here, I would like to state my argument against the motion. At first, I would like to say the judiciary should not have the judicial review power because uh, judiciary should not have the judicial review power on these grounds. First of all, judicial overreach. Courts often cross their constitutional limits when पार्लियामेंट एंड लेजिस्लेटिव का काम है लॉ को बनाना और एग्जीक्यूटिव का काम है उन लॉ को इम्प्लीमेंट करना तो जुडिशियल रिव्यू डायरेक्टली वायलेट्स the doctrine of separation of power. Second, subjectivity of judges. Judicial decision will not always purely objective. Judges can be influenced by their personal, political influence, ideologies, values, and social backgrounds. This creates inconsistency and unpredictability in constitutional interpretation. Third, overburden in judiciary and misuse of judicial review provision. Judicial review is a time-taking process. It may used for publicity or personal agendas, burdening in judiciary and delivering focus for genuine issues. देश का जो असली मुद्दा है जो असली समस्या है उन पर सरकार का दृष्टि और कोर्ट का दृष्टि हटाने के लिए जुडिशियल रिव्यू का मिसयूज हो सकता है लैक ऑफ अकाउंटेबिलिटी जुडिशरी is not directly accountable to the people like legislature and executive. There is no electoral check on judges of courts. So it makes judiciary to unchecked authority. 5. Policy paralysis. Frequently, judicial review interference in policy matters. It slow down to good governance. Governance may hesitate to take bold decisions on role of parliament and which supposed to be parliamentary primary lawmaking body.
7. Inconsistency in judgments. So different courts and judges interpret constitution according to their personal ideologies and ideas. So for judicial review provision, various judgment come on various issues. So it I think it will be a direct violation of rule of law. Rule of law means not the equal protection of law. It also means the law should follow a direct law should follow a rule. Last, undemocratic nature and counter majoritarian difficulty. Judicial review allows unelected judges to overturn laws made by parliament. This this raise this raises a serious condition. Why should a small group of judges interfere or interpret their constitutional laws over the large group of people represent through voting system? So judicial review creates a situation where majorities will, through elected representatives, in overridden by a minority judges, which can be a contrary to democratic principles. So judicial review, not the protector of constitutional principles and fundamental rights of citizens. It also can be misused, and it also can violate of fundamental rights. So I would like to conclude my argument by saying that judiciary should not have judicial review power because it gives absolute power to judiciary.
Thank you, CADC 21. CADC 22, are you available now?
Yes, sir. Actually, the network connection was low because I had connected through hotspot. The network in my building was not working well since last night.
Is it fine now?
I'm
Are you in a position? Are you in a position to speak? Start with deliberation.
Yes, sir. Actually, I will start, but I don't know if any interruption could occur during the meeting, but I'll try my best to stay flawless throughout the speech.
So you must start with deliberation.
Okay, sir. Should I start?
Yes, you may start.
Sir, should I start?
You may start.
Okay, thank you, sir. Honorable judges and esteemed audience, it is with great pleasure and responsibility that I am beginning this motion, and hopefully, by the end of this speech, most of the misunderstandings regarding judicial review will be wiped off. So, let me begin by simple logic that be it a solar system, a planet, a country, city, or even this debate, all of this revolves around a law of constant. And this law of constant remains same throughout the system, throughout the game. No matter that there may be some protocols which may be added around the system, but the basic law of constant remains the same. The same is true for our societal and our polity structure, wherein the main rules for our society have been defined by those who in their utmost intellectual presence inscribed them in the constitution on behalf of the people of our country. So in order to keep this order intact, we need an institution which protects its basic features from being overturned. And that is where the judiciary, along with judicial review, comes in. Honorable judges, the very Latin meaning of the term judiciary comes from judicium, which means to judge. So, denying the basic right to function for judiciary is like denying the legislature not to make laws or the executive not to execute them. Herein, I would like to add some quotes of some eminent personalities as to what they actually said in this August Constituent Assembly. For example, Dr. B.R. Ambedkar apart from referring to Article 32 as the heart and soul of the Indian Constitution, also mentioned on 13th of December 1948 that in a federal constitution, it is always open for the judiciary to decide whether any particular law passed by the legislature is either ultra vires or intra vires to the powers provided to it by the constitution. In fact, members like Sri Damodar Sarup Seth had such confidence on the viability of the judiciary that he even went on to suggest on 10th of December 1948 that the Constituent Assembly must not need the safeguards or the protection for the unit of federation in the form of a second chamber. In fact, the prerequisite protection has already been provided in the form of judicial review in the distribution of the powers among the organs of the government, and thus we also have Article 131 inscribed in our constitution, wherein judicial review plays an important part. Next, speaking on the writs, Mr. Naziruddin Ahmad on 9th of December 1948 went on to suggest that fundamental rights should be capable of being enforced by any court of law. In fact, that can be either criminal or civil. And he meant that the problem of accessibility should be removed from our judicial system, and judicial review should be able to protect the rights of each and every citizen in the remotest part of our country as well. In fact, Shri H.V. Kamath on 9th of December 1948 had suggested in the assembly that the choice of writs to be exercised in a particular case, this discretion should be left with the Supreme Court as to which writ they want to use in which particular case. Honorable judges, our constitution is a unique blend of many good provisions which had been adopted from the rest of the world, which were debated rigorously for their implementation in our country's context. For example, the framers, though wanted a constitution to look modern and amendable with time so that it is actually seen as a living document, at the same time, they wanted to keep our core values of the constitution intact. So they created judiciary as an institution which functions as a sentinel for protecting the rights of the citizens as well as the core values of a constitution. And in this, judicial review plays an important part. Next is that there was a huge debate surrounding whether due process of law should be adopted or procedure established by law as seen in the Japanese constitution should be adopted. And I even recall that Dr. B.R. Ambedkar had even said that it's like walking between Scylla and Charybdis because the decision was so tough. So in the end, though the assembly had adopted procedure established by the law, and that may have been because of the influence they had while witnessing the due process of law work in in the judicial system of United States. But at the same time, the very principle that the procedure established by the law must be fair, just, and reasonable has already been enshrined in the articles of 14, 19, and 21, and thus they must form a golden triangle, as in they must cooperate with each other to protect the justiciable fundamental rights of our citizens. And maybe that is why Professor K.T. Shah had even famously said that the legislature in a democratic assembly is bound to be influenced by party reasons rather than reasons of principle. Therefore, he stated in another conversation that judiciary must be above any suspicion and therefore it has to be above any contamination. Honorable bench, with the independence of our nation, the Constituent Assembly had adopted first past the post system (FPTP) for our legislature, wherein the majority is always in power. So it would be wrong to think of the government of India as the government which has been elected or the mandate. It is the mandate of the people of our country. Rather, it is the mandate of the majority which might be influenced by party politics. So that is why the judiciary comes in as a sentinel on the qui-vive and protecting the rights and interests of not just the majority but also of the minorities. Honorable bench, lastly, I would like to introduce a new facet to our debate wherein I would be providing three important logical arguments on the importance of judicial review as a practice which finds firm ground in in the constitutional values and in our Constituent Assembly debates. So the first is the counter majoritarian difficulty argument, which was given by late Professor Alexander Bickel in his book The Least Dangerous Branch, wherein he stated that the legislature might represent the momentary will of the majority. Judiciary must stand as the sentry of the enduring values which have been inscribed in the Constitution. the same which has been highlighted in Articles 13, which declares any law as void, which is ultra vires to the powers provided to it, or whether it be Article 32, which provides writ jurisdiction to the judiciary and provides protection to the aggrieved. So this major argument was also highlighted in the speech of Sri Mahavir Tyagi, wherein he stated that elected legislature would represent the majority even if it is 51%. Therefore, there should be a mechanism that the rest of 49% can be protected through an unbiased system. Our next argument is that in his landmark book Taking Rights Seriously, Ronald Dawkins had proposed the moral reading of the Constitution. He had argued that terms like liberty and fairness are not just an ink on paper, but moral principles that the state must protect, and it must protect to achieve its dignity. Yeah, and this very argument was also highlighted in the articles like Article 14, which provides equality before law, and Article 19, which provides liberty of speech and expression. So Justice John Rawls, in his book A Theory of Justice, even mentioned that in a just and equitable society, certain liberties are non-negotiable and therefore they cannot be replaced in exchange of any economic gain. And that is why judicial review becomes even more important when the rights of the citizens might be hindered, citing nations' progress. So last but not the least, in a growing digital world, the judicial review would see its expanding role in interpreting the rights of the citizens as well as in protecting the core values of our constitution. With this, I'll depart from my speech. Thank you.
CADC 21. Would you like to exercise a rebuttal?
Yes, sir.
Okay, you receive your thanks first now.
So should I start?
Yes, please start.
Thank you, sir. So I want to ask how judicial review judicial review passed unbiased judgment, because judges of Supreme Court or other courts also human being, so they also have personal political ideologies, values, and social backgrounds. So they can be influenced by political ideologies, political influence, etc. And my opposite participant says that if Parliament can pass any unconstitutional laws, then judicial review helps us to protect it. I want to say in Parliament there is also government and opposition. So opposition can help to don't pass unbiased laws. That's it.
So I do agree with the fact that even the people who are sitting in the judiciary are human beings. But the very fact that why judiciary has been created it is that it is to resolve the disputes between the federations and to protect the very core values of our constitution. Now, if you say that the people sitting in judiciary are human beings, so going by that fashion, we can even say that the people in the other organs are also human beings, so they also might be influenced. And the fact that you said that the government of India, it represents the people of our country, so they might be eligible to provide to take decisions for them. But at the same time, I also mentioned in my speech that the majority might be even 51%. So for the interest for the rest of 49%, their interest to be protected, we need an institution like judiciary. And in when we see the institution of judiciary, there are two parties in an adversarial system as we follow in our country, where both the parties have equal chance to say their points. So there is a less chance of being the judges being unbiased. And yeah, that's my answer.
Well, thank you, CADC 21 and 22, respectively. Now I would like to call CADC 24 to start the deliberations.
Excuse me, sir. Sir, I have a doubt.
Yes, please.
Sir, can I even ask a rebuttal to 21 because I haven't asked it?
Okay, you may exercise your rebuttal.
Yes, sir.
CADC 22,
Sir,
you may
so
start the
my
rebuttal.
rebuttal is yes, sir. So, sir, my rebuttal is that just because 51% of people want something today, does it mean that they are allowed to take away the basic rights of the another 49% forever? So, a vote is a temporary mood, but a right is a permanent promise which is provided in the constitution. So, why should a short term vote kill a long term freedom?
So judiciary can also pass a biased judgment, and a politically influenced judgment can hamper the fundamental rights and basic structure of doctrine and preamble of India, which treated as preface of our constitution. That's it.
Ma'am, with your permission, can we call the next participant?
Yes, please.
CATC 24, you may start the session.
Good morning to the esteemed judges and good morning to the Mr. President Sir and all other members of the Constituent Assembly. I stand here before not as a member of the Assembly but as the property of the Republic. We are not here to write the book of the rules. We are here to forge a shield for the soul of India. If we grant the citizen right to speak, right to believe, and right to live with a dignity, but provide no power to strike down the laws that steal those rights away, then this house is engaged in the exercise of futility. Yes, in the preamble, we the people of India, the extreme power, the supreme power is a democracy. Yes, whether the India should be follow the parliament democracy or the constitutional democracy. Yes, India should be follow the constitutional supremacy, not the parliament supremacy. If the constitution is supreme, then there must be somebody to enforce it. Otherwise, law will enforce and it will violate the rights. The government will act arbitrarily. That someone is a judiciary through the power of judicial review. Sir, look at the draft Article 8 on November 25, 1948. We made an attempt to establish the sentinel on the QY. It ensures that the will of the moment will never eclipse on the will of the Constitution. The class 1 is voids all pre-constitutional laws which is inconsistent with the fundamental rights. Class 2 forbids the state for making any future laws that abrogates the fundamental rights. But the real tension is between the class 3 and the class 3 class 1, where the Ambedkar defined law includes ordinances, bylaws, rules, regulations, critically customs and usages. Here, the other assembly member, Mr. Nasruddin Ahmad, made an amendment number 260. He in the amendment, he deleted the word law does not include customs and usages. He argued that it was absurd to say that the state cannot make a law and then include custom in the definition. But custom is not made by the state, not made by the peoples, it grows. But the real drafting committee made a futuristic act. Dr. Ambedkar added a master key. The text is unless the context otherwise requires. Why? Because if the law does not include custom, the court will be helpless. The ancient inequalities that haunt our temples and kitchens, without the power, maybe the untouchability will remain, the women inequality will remain, the Dalit will not enter into the temple, the women will not enter into the temple in the future. Yes, we rejected the amendment number 260 because the judges, the judiciary must have the power to review the customs or usages. Then, other members like named Damodar Swarab Seth and Mahbub Ali Beg raising a chilling doubt about Draft Article 7 and Draft Article 13 have a definition class about state. State includes central government, state government, and they include the other authorities. Now the critical confusion is, could a petty officer or any other local authority use the draft Article 13 Class 2, which is the restriction of the freedom, fundamental freedom, to abrogate rights? The Ambedkar is clear. This confusion is, there is a objective of the fundamental rights into twofold. The one thing is, every citizen must be in the position to claim these rights if it is violated by the law. And second fold is, these rights must be binding upon every authority. It must not only for central, it must not only for the provisional, it must be for local or even the petty official. It is created by the law. So the tension between Article 8 and Article 13 was resolved on the day December 1, 1948. If the pre-constitutional law, what is the doubt? If the pre-constitutional law it is inconsistent, it becomes inoperative, but the rest will continue. But the new fear arose from the Sardar Hukum Singh because of the third Article 13, draft Article 13 Class 2 is, nothing shall prevent the state making any law. So it creates a tension. What happens if the legislature restricts our own destiny? That the same doubt which is raised by the Vice President, Mr. Mukherjee, the destiny of the people decided by the executive and legislature are the courts. But his submission is, the Supreme Court should be the ultimate, be the arbiter, and should have final say in the regard of destiny of our own nation and the citizen. So the answer came from Mr. Thakur Das Bhargava because he made an attempt for the amendment. He added the reasonable word before the restriction. By adding the reasonable before the restriction, the judiciary was finally made an ultimate arbiter. It is the court, not the politician, who will decide if the restriction is necessarily or a tyranny. Then, finally, sir, we face a ghost of draft Article 15 on September 13, 1948. The debate was going on between the two things, the procedure established by law and due process of law. Dr. Ambedkar moved a substitute of due process and deleted the procedure established by law, and the two positions were discussed. If we trust legislature, we risk a house packed with the party men, the whim of majority. They might be make bad laws to abrogate liberty, to abrogate the fundamental rights. And if the trust judiciary, we risk the 5 or 6 gentlemen sit in the federal court or the Supreme Court using their individual consents, using their bias, using the prejudice mind to sit in the judgment over the people, over the majority of the people. So Ambedkar admitted it is a danger on both sides, but his intention was clear in the amendment number 523 to give the judiciary the power to check not if the law is made with the exceed of authority, but whether law is good or bad. Though the amendment was negative, not adopted in the Constituent Assembly, but the objective of the Constitution is by the drafting people was to promote the constitutionalism, that is limited government. The three organs must act separatively, but the functions has been checked, and the independent checker is the judiciary. Sir, my final submission is, the Supreme Court is the ultimate arbiter of the destiny of our national. We cannot leave the rights of the people to be regulated solely by the executive or the legislature. We promote a government of limited powers. We promote a republic where individual is protected from the state. Therefore, I strongly support the motion. The judiciary must have the power of judicial review. It is the only brilliant organ capable of ensuring that the light of our preamble is never extinguished by the shadows of bad law. I have spoken, sir. Thank you.
CADC 23.
Yes, sir.
You may start.
Am I audible?
Yes.
Okay, sir. Imagine a bridge, a massive bridge that connects two sides of the nation, justice and governance. Now imagine we appoint an engineer to ensure that bridge is strong, safe, and fair for whoever who crosses it. But over time, the engineer begins deciding who can cross and who cannot, the vehicles which can go, which cannot. Now the engineer is not maintaining the bridge, he is controlling it. Ladies and gentlemen, the judiciary is that engineer. And judicial review is the authority that we give to the to ensure to bridge does not collapse under unconstitutional weight. But here, the question we must confront is when the engineer begins to control the bridge, who controls the engineer? सोचिए कितना हास्यपद होगा जब मैं यह कहूं 140 करोड़ की आबादी है हमारी, सबसे बड़े लोकतंत्र हैं हम, परंतु एक कुर्सी राज नहीं कर सकती, लेकिन हाँ एक बेंच जरूर राज कर सकती है. Greetings everyone. Today I stand firmly against the motion. Does the judiciary require judicial review? My answer is no, not in its current, oversized and unchecked form. And as our old shlok reminds us, yatra dharma tatra jaya. परंतु धर्म लोगों के विश्वास से आना चाहिए, ना कि एक ही बेंच के निर्णय से. And let me be very clear at the outset. This is not an attack on the judiciary. I respect judiciary. It is essential. It is necessary. But the question isn't whether courts must exist or function. The question is, what do we want? Unelected judges versus elected representatives. Ballots or courts. Accountability or imposed decisions. Now, notice the irony. The word judicial review does not even occur in the constitution. जी हाँ, B.R. अम्बेडकर द्वारा लिखे कॉन्स्टिट्यूशन में यह शब्द जुडिशियल रिव्यू आता ही नहीं है. But let us not forget, when the court says it is our duty to protect, it is actually saying the ball is in my court. Now my opponents may cry, the court is our guardians, it is our protectors. अगर घर पे एक चौकीदार ही नहीं रखेंगे तो घर सुरक्षित कैसे रहेगा और जाने क्या क्या. But let us not forget, अगर न्यायपालिका ही एकमात्र चौकीदार बन जाएगी तो लोकतंत्र ही नहीं, संसद की छत भी धीरे धीरे टूटने लगेगी. And let us now see what problems may occur if the constitution enjoys this supremacy. First and foremost is the core imbalance. Unelected judges versus elected representatives. Judges are not elected. They do not face elections or voters directly. Still, they can cancel, they can amend any constitutional law that is directly involved in the lives of 140 crore people. अत्यधिक न्यायिक हस्तक्षेप लोकतंत्र में जनता की आवाज को कमजोर कर देता है. Second point, inconsistency, subjectivity and confusion. Lord Acton once said, power tends to corrupt, and absolute power corrupts absolutely. Different benches may give different interpretations on the same constitutional law. Judges are humans too. They have their own values, opinions, and even theories. What is unconstitutional today may be constitutional tomorrow. जी हाँ, जो आज गलत है वो कल सही भी हो सकता है. Third, a democracy rests on simple but powerful principle. Laws are made by those who are elected by the people. When the courts repeatedly strike down laws, it kills the essence of democracy. Judicial review is turned into judicial supremacy. 140 crore people vote, decide and choose. But only 5 people in black robes decide what must go and what cannot. Fourth, unequal separation of powers. A healthy democracy requires balance. The legislature must make laws, executive must implement them, and judiciary must interpret them. लोकतंत्र 3 स्तंभों पर खड़ा है, परंतु जब एक स्तंभ अपनी ऊंचाई बढ़ाने के लिए दूसरे की जगह घेरने लगे तो पूरी संरचना डगमगाने लग जाती है. जहां न्यायपालिका अपनी सीमा भूल जाती है, वहां सत्ता संतुलन बिगड़ जाता है. And these are not just my opinion, not just theory. Let me prove this through examples. When Bal Gangadhar Tilak criticized the British in his writings, he was charged with sedition under an expanded meaning of disaffection. The court stretched interpretation so far that even criticism was treated as crime, suppressing freedom or speech. Marbury versus Medicine. Again, established the courts can strike down the laws that go against the Constitution. Led by John Marshall, it gave the judiciary the power of judicial review. महात्मा गांधी ने बिल्कुल सही कहा था, सबसे ज्ञानी भी गलती कर सकता है, सबसे ताकतवर भी गिर सकता है. Then why no institution, however noble, should not be allowed to cross the line of overreach while claiming to protect the Constitution? So, in a nutshell, I do not say the judiciary should have zero review power. A limited protective power to guard basic rights is necessary, but the current expanded power is dangerous. And let me end with an example of Mahabharata. भीष्म पितामह ने जब शक्ति को धन के बांध कर रखा और स्वार्थ की लगाम पर अपने आप को थाम कर रखा, जब अश्वत्थामा ने क्रोध में असत्र उछाला, अन्याय की आग में अपना ही घर जला डाला. जब तक शक्ति जिम्मेदारी हो तब तक ही वह धर्म की रक्षा करती है, पर जब शक्ति जुनून बन जाए, भावनाओं की दासी बन जाए, तो वो अनर्थ ही घटाती है, सिर्फ अनर्थ ही घटाती है. धन्यवाद. आपका दिन शुभ.
CADC 24, would you like to exercise a rebuttal? CADC 24, would you like to exercise a rebuttal?
Yes, sir, I have a rebuttal about the member is strongly against the judges are unelected, they are only nominated. The courts are repeatedly strike down the laws. Yes, if the laws which is against the fundamental rights, which is abrogate the fundamental rights, it's only duty for the judiciary. If the separation of the power is unequal, as you member said, the separation of power is unequal, whether the question is whether India is following the strict separation of power, whether the separate organ like judiciary is the only power to enforce the fundamental rights or not, then what is the aim of Article 32 of Indian Constitution?
My dear opponent, I respect your question and I'll answer your question, and I hope you'll like feel the answer is correct. Well, the question you asked is simply says if judiciary increases its powers, what will happen? Let me tell you, judiciary judges are not elected, they are unelected judges. Well, elections are taken place and people choose the elected people. So, we cannot say that judges have the power to supremate or look after any laws that are going wrong. Also, elected people are the people chosen by the citizens. So, they trust them, they know they'll answer better and they'll help themselves. People can do their better. So judges do not require to enter. They need to do their own work. And I'll just respectfully say that elected representatives can guide better rather than unelected judges. And also, my speech made little things clear that you asked in the question.
Well, thank you, CADC 23 and 24. We would like to proceed with the CADC 26.
Sir, can I use my rebuttal question power?
Ma'am, but you have answered the questions.
Sorry, sir.
You have already answered the asked question.
Sir, I need to ask a question. Can I?
Ma'am, you have just 20 seconds left of your time. You may ask it again.
Sure, sir. As my dear opponent mentioned Dalits and also untouchability, I want to ask if rights and fairness can be protected to elections and constitutional amendments and public debate instead of concentrating power into the courts, then why do we require judges and judicial power?
Yes, from the preamble, we the people of India is a supreme power, but India is not following the parliament democracy. Yes, the parliament, the elected member have the power to make law, but who is going to check the law? If the parliament has always check their own laws, it is against the natural justice. No one should be judged for his own cause. And what is the role of the judiciary? They have to check the balance of the laws which is made by the parliament. That is a key role of the judiciary. What I want to mention in the Dalit and women are not allowed in the temple is if the law is does not include customs and usages, judiciary not have the power. Judiciary should be the answerless. Now the
Thank you
judiciary
so
have the
much, sir.
power to review
Thank
if
you,
the
sir.
custom.
We are overreaching the time.
Okay, sir. If the judiciary has a only power to review the customs which is good or not. Thank you.
Thank you, sir. Now I would like to call CADC 26 for the session. CADC 26. CADC 26.
Yes, sir. Movement.
Okay, you may start your deliberation.
संविधान के रक्षक न्याय का हकदार हो, कार्यपालिका विधायिका पर अंकुश का धार हो, मूलभूत ढांचे की जो करे सदा ही समीक्षा, न्यायपालिका के पास वे न्यायिक पुनरावलोकन का अधिकार हो। जब हमारे संविधान के निर्माता संसद के केंद्रीय हॉल में एकत्रित हुए थे, तो वे केवल कानूनी दस्तावेज तैयार नहीं कर रहे थे, वे एक सामाजिक राजनीतिक क्रांति को आकार दे रहे थे। वे कॉलोनियल रूल की काली छाया से अभी अभी उभरे थे, एक ऐसा शासन जहां लेजिस्लेचर अकाउंटेबल नहीं था, एग्जीक्यूटिव निरंकुश था और व्यक्ति के राइट ना के बराबर थे। Today, I am here to debate whether the judiciary should possess the power of judicial review or not. My stance is in the favor. My opinion is that judiciary is not infringement for democracy, but it is like an insurance policy for it. So here I am putting some facts from the Constituent Assembly debate, volume 7 and 11, and Dr. Baba Sahib Ambedkar writing uh, speeches 13 and 15. According to our sources, B.R. Ambedkar support a strong judiciary as the guardian of rights. जब इन्हें सोशल रिफॉर्म की जानकारी हुई तो उनका मानना था कि फंडामेंटल राइट जो मौलिक अधिकार है उनका उल्लंघन का निवारण होना चाहिए। As in on debate on November 25, 1949, उनका जोर था कि जुडिशरी न्यायपालिका को राजनीतिक प्रभाव से मुक्त होना चाहिए। उनका यह भी मानना था कि न्यायिक आज्ञाकारिता से बंद होने के बावजूद अन्यायपूर्ण निर्णयों का सम्मान करने के लिए बाधा महसूस नहीं होनी चाहिए। As opposition will give argument that legislature is elected by people and that's why it should be supreme. He said temporary majority, minorities and marginalized could be easily trampled. That's why B.R. Ambedkar foresaw this danger brilliantly. When debating fundamental rights, he was asked which article was considered most important. He pointed out Article 32, right to constitutional remedies, which empowers Supreme Court to issue writs to enforce these rights. Dr. Ambedkar stated on the floor of the assembly that if I was added to name any particular in this constitution as the most important, I could not refer any article except the Article 32, as it is the very of the constitution and very heart of it. So I am putting some cases relevant to this agenda. In there was a case of 1948. There was a case of 1950 A.K. Gopalan versus State of Madras. While the court largely upheld the Preventive Detention Act, it struck down Section 14, which prevented detainees from disclosing their grounds of arrest to a court. This proved that judicial review is not necessary. Is necessary to keep the hallways to justice open. Otherwise, the executive could imprison citizens in total secrecy. Next case is of 1950 Romesh Thapar versus State of Madras. The government banned the circulation of the General Crossroad, citing public safety. The court gushed the ban, ruling that public safety was too broad a reason to suppress free speech. This case proves the judiciary is needed to define the limits of state power, so that dissent is not silenced under the guise of order. And the next case is of 1915 Brij Bhushan versus State of Delhi. Decided along Romesh Thapar, the court struck down a pre-censorship order on the general organizer. It established that preventive censorship is unconstitutional, proving that judicial review is the only sheet protecting the freedom of the press from executive overreach. So here I mentioned that proof that judicial review is necessary by the judiciary. And there is about next that there are also many cases except the timeline. But here I am some quoting about the facts of preamble. That preamble is a source for constitution that proves that we the people, the preamble establishes authorities derived from the people, not the legislature. Judicial review ensures that elected representatives do not betray the original mandate by passing the law that contradicts solemn resolution. It guarantees justice. Preamble pledges social, economic, and political justice. Since the judiciary is the primary organ tasked with delivering justice, judicial review is the practical tool it uses to strike down laws that cause injustice or inequality. In preamble, it is also mentioned that sovereign democratic republic. For a nation to remain a republic, the government must operate within the rules, not according to the whims of officials. Judicial review prevents a democracy from sliding into tyranny of the majority by ensuring all laws align with the constitutional blueprint. So here I am concluding my speech. Let us ask ourselves what happened when judicial review is or removed or diluted. History gives us answer. Without an independent judiciary, the executive becomes an elected dictatorship. Right becomes privilege that can be revoked. To oppose judicial review is to oppose Dr. B.R. Ambedkar. Thank you.
CADC 25.
Can I start?
Yes, ma'am.
Honorable judges, worthy opponents, and respected members of this House. Today, we approach a question that lies at the very heart of government. How does a society balance the power of people's elected representatives with the principles of the Constitution? सवाल ये नहीं कि कौन सही और कौन गलत, सवाल ये है कि लोकतंत्र में आखिरी फैसला लेने का हक किसका है, जनता के चुने हुए लोगों का या बंद कमरों में बैठे हुए जजेस का. This debate often presents a false choice between pure democracy and judicial protection. We believe that the most fundamental right is the right to participate, the right of rights. And when we'll allow a court to strike down a law, we are telling people that unelected judges have more power than 500 plus elected representatives of the legislature as well as executive. Judicial review gives the court the power to overrule the majority opinion of the people's representatives. And such power handed to an independent institution is a very risky gamble. What if there's a point in the future when the judiciary threatens our sovereign parliament? When it declares supremacy under the name of constitutional law or fundamental rights and we won't be able to do anything about it? When it interpret the constitution however it wants to because we gave it the right to, a right we won't be able to take back. हम नेताओं को भ्रष्ट कहते हैं, but how do we know the judiciary won't be just as penal? I agree, there may be times this power will be used to stop blunders by the government. But how do we know the same power won't be used to do whatever they want? But at the end, we have to put our trust somewhere. But it would rather not be in a power that we cannot revoke. Even though Article 13 and 226 give the judiciary the right to intervene for fundamental rights, Article 368 gives the power to the parliament to amend its own constitution, whose sovereignty may be threatened by judicial review. Yet, if the intervention is just for fundamental rights, there would be no issue. But who's to keep a check on that criteria? Defenders of judicial review often claim it is the only way to protect rights. Yet history proves this to be a fallacy. In United States, in Lochner versus New York 1905, the court struck down a law limiting bakery worker hours to 60 hours weeks, prioritizing freedom of contract over public health. This created the Lochner era, where the court spent decades dismantling labor protections, proving that judicial review is a tool for the elite interest to paralyze social progress. In the end, we saw courts strike down over 170 labor laws designed to protect workers' rights. In Liver Siege versus Anderson, United Kingdom, November 1942, the judiciary failed by blindly trusting the executive's vague, reasonable beliefs and allowing detention without proper scrutiny. Instead of acting as a check on the power, the court surrendered their role, showing that judicial authority is capable not just of overreach, but of complete inaction when it matters most. हम ये तो चुन सकते हैं कि सरकार कौन चलाएगा, पर ये नहीं चुन सकते कि अदालत में कौन बैठेगा। और जब आखिरी फैसला लेने का हक उन लोगों के पास चला जाएगा जो हमें जवाब भी नहीं देंगे, तो वो न्याय नहीं, वो एक नए किस की गुलामी है। We are often told that the gavel is a shield, but when that very shield will be used to strike down the collective will of a billion souls, it will become a barrier to the very progress it claims to protect. Sovereignty is not a gift bestowed upon the people by a court. It's the inherent power that flows from the ballot box to the benches of this house. We must confront the reality of the counter-majoritarian difficulty, the fact that a handful of unelected individuals can paralyze the progress of the entire nation. We call our democracy the system of checks and balances, but what will happen the day the judiciary needs to be checked on? Our judiciary will be a closed-door club where the sovereign people are not even invited. An independent judiciary is essential in a democracy, but parliamentary sovereignty is the very soul of it. In conclusion, the ideal judiciary may not be a compliant one, but one where the final verdict lies in the hands of the people. The need for a judiciary is undeniable, but to give it an unstoppable power, that will either be the best thing to have ever happened in democratic history or the worst democide the world has ever witnessed. Thank you.
CADC 26, do I have any counter question with CADC 25?
Yes, ma'am.
You can ask.
ma'am,
You
yes.
have only 1
Yes, sir.
minute. Please continue.
ओके मैम, जैसे इनने कहा कि नेताओं का काम जनता की इच्छा को लागू करना है, लेकिन उनका निर्वाचित होना जरूरी नहीं है। लेकिन जजों का काम लोकप्रिय होना नहीं, बल्कि कानूनी रूप से सही होना है। जैसे अगर जज चुनाव लड़ेंगे तो वे कानून की बजाय उन लोगों के पक्ष में फैसला सुनाएंगे जिन्होंने उन्हें वोट दिया है। इससे न्याय प्रणाली एक पॉपुलैरिटी कॉन्टेस्ट बन जाएगी।
I agree with what you're saying, but if the judiciary is unelected, then if वो कुछ भी करे, हमें उसको मना करने का कोई हक नहीं होगा. They don't have to reason with us. They don't have to reason with anything. They can strike down the parliamentary laws, the parliament which we have elected. So the judiciary may be unelected, but that is the main problem. Because how can something that we have not even chosen strike down the law of people we have chosen by ourselves? And moreover, you said that the judiciary is an insurance policy. But what will happen when that insurance policy will go out of hand? उस पे न्याय रखने के लिए कौन होगा? उस पे कौन चेक करेगा? And the executive could imprison people. How could it imprison people if we choose the executive? If we choose if they stay or not, then there is no way that they could imprison us.
Okay, we'll move forward then. CADC 28. CADC 28. You may begin. CADC 28. Are you there?
Yes, ma'am. Yes, ma'am. Am I audible?
Yes, you are audible. You may begin with your arguments.
Okay, ma'am. Honorable judges, distinguished panelists, my worthy opponents, and the fellow participants. I am here today not merely to argue a legal position. I am here to defend a decision made by the greatest deliberative body this nation has ever assembled. the Constituent Assembly of India. My opponents may say that giving courts the power to strike down the laws disturbs democracy, but I asked what did the framers themselves say? Because this is a constituent assembly debate competition, and the truest answer to any constitutional question lies not in the textbooks, not in the courtrooms. It lies in those 12 extraordinary volumes where our founding generation argued, agonized, and ultimately chose. And they chose judicial review consciously, deliberately, and passionately. And let me show you why. When Dr. B.R. Ambedkar introduced the draft constitution on 4th November 1948, he confronted this question head on in the assembly. He acknowledged that different model existed, the British model of parliament supremacy, the model of constitutional supremacy where the constitution stands permanently above the parliament. He told the assembly that the draft constitution had deliberately sought to avoid the weaknesses of both the systems. It would not give the parliament the power to operate in ways that destroyed the constitution foundational character. This was a philosophical choice of the highest order. The framers were not ignorant of the parliament democratic legitimacy. They respected it deeply, but they understood something equally important. A written constitution is meaningless if the body it seeks to control can freely override it. In the assembly, E.T. Krishnamachari, one of the most vocal members of the drafting committee, warned on the floor of the assembly that without enforcement mechanism, fundamental rights would become nothing more than a pious declaration. Beautiful words with no force whatsoever. The framers have lived under a colonial legislation that was perfectly legal but foundationally and fundamentally unjust. They built judicial review precisely so that the legality and constitutionality would never again be confused. If the constitution establishes a higher order, a law above the parliament, then someone must have the authority to declare when ordinary law crosses that higher line. That authority must be independent of both legislature and the executive. That authority is judiciary, and the power of examination is the very definition of judicial review. The framers knew this, and this is why they built in it. No moment in the Constituent Assembly debates better capture the framers' intent than the Dr. B.R. Ambedkar statement on the Article 32, the provision that empowers every citizen to approach the Supreme Court directly for the enforcement of their fundamental rights. On the floor of the Assembly, Ambedkar declared that if he were asked to name any particular article as the most important, an article without which the Constitution will be a nullity, it would be Article 32. He called it the very soul of the Constitution and very heart of it. Now think carefully about the Article 32 actually does. It gives every Indian citizen the right to approach the Supreme Court and say this law, this executive action violates my fundamental rights. Examine it and strike it down. That is a judicial review. And here is the constitutional logic my opponent cannot escape. If rights without enforcement are merely pious declaration, and the framers said exactly this, then you must logically defend the enforcement mechanism. You cannot want rights without wanting the powers that makes rights real. Think about what happens without this. If the parliament today passes a law that directly violates Article 21, the right to life, no court can strike it down, then Article 21 does not protect your life. It merely decorates your constitution. The man who drafted this constitution called 32 its soul. My opponent are asking you to remove the soul and call the body alive. Let us examine Article 13 and what the debates around it reveals the framers' intent. The framers chose a specific and a deliberate word void, not voidable, not challengeable, but the word void. They declared all inconsistent laws with the fundamental rights shall to the extent of the inconsistency be void. Sir Aladi Krishnavanmi Iyer, one of the most legally accomplished members of the assembly, defended this formulation powerfully. He argued that the void was essential because courts were not merely the note of inconsistency and moved on. They were obligated to treat such laws as non existent. He made a foundational point. The Indian constitution was not merely a organizing governmental machinery, it was established a higher law. And for a higher law to function, someone must have the authority to declare when ordinary law crosses the line that the higher law draws. Now follow this architecture to the logical conclusion. The framers made the constitution supreme, they made the fundamental rights enforceable, they made the inconsistent laws be void, and they gave citizens the right to petition to the Supreme Court. Every single of these choices points in one direction towards an independent judiciary that examined legislation against the constitution. These features are not separate provision, they are interlocking system. Pull judiciary review out and the entire architecture of this collapses. This is why no parliament can constitutional insulate all the laws from the scrutiny. A constitution which cannot be stripped of its enforcement mechanism by parliament majority is not a constitution, it is a literature. And attempting to do so is a legislation, it is a constitutional fraud. It is equally important, perhaps the most important, to look what the assembly itself rejected. During the debates, 13 members proposed amendments that would have narrowed down the court jurisdiction, that would have given places certain classes of legislation beyond judicial challenge. They were not minor proposals, came from the members who genuinely believed in the parliamentary primacy. They argued their case, the assembly heard them, and the assembly voted them down. Time and again, across multiple sessions, multiple volumes of debate, multiple votes, the assembly consistently chose to preserve and strengthen the judiciary role as the constitutional guardian. It was endorsed by the democratic will of the assembly itself, expressed through votes, through deliberation, through the most transparent constitutional process in the entire history. My opponents speak of democratic legitimacy. The Constituent Assembly is a democratic legitimacy, and the Constituent Assembly chose this. In my conclusion, my opponents will speak of majorities and the parliamentary wisdom. I respect those values. The framers respected them too, but I asked them to answer the one question that the framers themselves answered in 1949. What use is a constitution that the parliament it governs can freely destroy? The framers knew that the majority are temporary, but injustice, once entrenched in law, can be a permanent flaw in this country. They knew that a constitution without the enforcement is not a law, it is a literature. And so they built with full deliberation and full democratic consent a system where the constitution stand above the parliament and where an independent judiciary stand guard over the constitution. That is not a threat to the democracy, that is a democracy promised to itself that no majority, however powerful, in any frame of time of this country will be permitted to extinguish the rights of the individual or the freedom of the minority that this constitution was written to protect. The framers sealed the promise into a very architecture of this document. Judicial review is lock on the seal, and I am proud to stand for the motion. Jai Hind.
CADC 27. CADC 27. CADC 27.
Yes, sir, present.
You may start your deliberation.
Sure. Respected judges, honorable opponents, and my dear friends, a very good morning to all of you. The Constitution is not merely a legal document, it is a living instrument of the governance. And like every instrument, it must function with balance, not domination, by any one organ. With this perspective, I stand against the motion, arguing that the judiciary should not have excessive power of judicial review. The real issue is not whether rights should be protected. Of course, they should, but whether concentrating that power too heavily in one unelected institution disturbs the democratic balance. Let me begin with the question. In a democracy where the people are supreme, can unelected judges repeatedly override the will of elected representatives. जनता कहती है हमने वोट दिया है, हमने सरकार चुनी है, पर कोर्ट क्या कहती है? कोर्ट कहती है हम उस निर्णय को ही रद्द कर सकते हैं. This raises a serious question and a serious concern. Does judicial review, when excessive, begin to dilute the voice of the people? The concept may be originated from the Marbury versus Madison, the leading case. But India's constitutional design is rooted in the parliamentary supremacy within the constitutional limits, where parliament reflects the aspirations of millions of people. Indeed, I refer the Article 32, the heart and soul of the Constitution. But the larger vision was one of checks and balances, not the judicial supremacy. It emphasized that no organ should become so powerful that it overshadows the other. डॉक्टर अंबेडकर का उद्देश्य था अधिकारों की रक्षा करना, लेकिन साथ ही साथ यह भी सुनिश्चित करना कि कोई संस्था सर्वशक्तिशाली ना बन जाए. If judicial review becomes too expensive, it risks turning the judiciary into a policy-making body, which was never its intended to be the policy-making body. कानून बनाना संसद का काम है, नीतियां बनाना सरकार का काम है, और कानून की व्याख्या करना न्यायपालिका का काम है. लेकिन जब सीमाएं टूटती हैं, तब असंतुलन पैदा होता है. Jawaharlal Nehru strongly believed in the strength of parliamentary democracy. He saw parliament as a primary forum where people's aspirations are debated and transformed into the laws. नेहरू जी यह मानते थे कि लोकतंत्र की असली शक्ति संसद में ही है, और हर निर्णय न्यायिक हस्तक्षेप से डर के लिया नहीं जा सकता. तो क्या यह लोकतांत्रिक प्रक्रिया को कमजोर नहीं करेगा? Frequently, the judicial intervention can create hesitation in the governance, where decision makers begin to act decisively rather than defensively. A major turning point in the case Keshwananda Bharati versus State of Kerala, where the basic structure doctrine was introduced. Ladies and gentlemen, I strongly believe that while it aimed to protect the Constitution, its scope was open-minded and open-ended rather than undefined. मूल संरचना क्या है, कहाँ लिखी है, और इसे तय कौन करेगा? अंततः न्यायालय ही. This creates a situation where judiciary has the final say on constitutional limits, which can lead the uncertainty and subjective interpretation. Let us look at this through a practical lens and units. In any system, clarity of roles is essential. Imagine a game where the referee not only enforces the rule but also modifies in the mid-game, like in cricket. खिलाड़ी कहेगा नियम तय है, हम उसका पालन करेंगे. रेफरी कहे नियम मैं बदल दूंगा, तो क्या खेल निष्पक्ष रहेगा? Similarly, when courts step into policy domains, the line between interpretation and legislation begins to blur. Now considering the army viewpoint, where discipline, hierarchy, clarity of command, and the backbone of the functioning. सेना का सिद्धांत है एक आदेश, स्पष्ट आदेश. यदि हर निर्णय में अलग अलग हस्तक्षेप होने लगेंगे तो भ्रम पैदा होता है, और उस भ्रम में युद्ध भूमि में हार का कारण बन सकता है. In the matters of governance, especially the national security, decisions often require the speed, confidentiality, and decisiveness. Excessively in the judicial review, it is introduced that delays and second guessing, which occur not always by practical in such a sensitive areas. In the case of in KS Puttaswamy versus Union of India, the expanded individual rights it expanded the individual rights significantly. While this is commendable, it also highlights how the judiciary is increasing the stepping areas that overlap with policy making. हर निर्णय एक मिसाल बनता है और धीरे धीरे न्यायपालिका नीति नियमों और निर्माण के क्षेत्र में प्रवेश करने लगती है. यहीं से सीमा धुंधली होने लगती हैं. Supporters argue that the judicial review is essential to protect the rights, but we may ask, is protection effectively if it disturbs democratic accountability? जवाबदेही किसकी है? संसद की. निर्णय लेने की शक्ति किसके पास है? लोकपालिका के पास. तो संतुलन कहाँ बिगड़ा? पूरी व्यवस्था से ही बिगड़ा, पूरी व्यवस्था के भीतर ही बिगड़ा. Judges are not elected by the people, yet through judicial review, they can overturn decisions made by the elected representatives. This creates a democratic paradox. The preamble promises justice, liberty, and equality, but these ideals must be achieved through a democratic process, not through the concentrated power. At last, I conclude that संसद कहती है हम कानून बनाते हैं, कार्यपालिका कहती है हम उसे लागू करते हैं, न्यायपालिका कहती है हम उसकी व्याख्या करते हैं, और संविधान कहता है संतुलन बनाए रखो. यदि यह संतुलन टूट गया तो लोकतंत्र भी कमजोर हो जाएगा. Therefore, while judicial review is an important safeguard, its excessive or unchecked use can disturb the delicate balance of the power. What India truly needs is not unlimited judicial review, where no institution dominates. The Constitution remains supreme through harmony, not through the conflict. Jai Hind, Jai Bharat.
The AGC 28, would you like to exercise the rebuttals?
Yeah, I want to do the rebuttals. So, may I start?
Yes, please.
So, my opponent has confused the guardian with the ruler. The constitution is supreme and not the parliament, not the judiciary. Judiciary review does not place the judges above the parliament. It places the constitution above the parliament. The judge is not the master, he is a constitution voice. And who gave the court this role? Not the judges themselves. The Constituent Assembly did through Article 13, 32, through deliberate votes on the floor. And so, if my opponent has a problem with the judicial supremacy, the argument is not with the courts, it is with the Dr. B.R. Ambedkar and the framers themselves. In the first stanza, he was saying that the unelected judges are overriding the elected parliament is undemocratic. The Constituent Assembly, the most democratically elected body this nation has ever saw, deliberately gave the court this power. If judicial review is undemocratic, then the framers themselves were undemocratic. My opponent is arguing against the assembly and not against me. So my simple question is, if parliament tomorrow passes a law that strips down every citizen of their right to life under Article 21, who stops it? Because right now, majority is in their hand and they can pass any law. Then who stops it?
I answer
AGC
your
27.
rebuttal question.
Yeah, your rebuttal time starts now.
Sure. As my opponent said, I said the judicial review is strongly against the But my argument is not against the judicial review, but it is against its excessive and unchecked powers and unchecked use. As he also mentions my point that the parliament should be supreme over the constitution. This is not my point, but they are testing this. You understand the constitutional supremacy versus parliamentary supremacy. The constitutional is supreme, not the parliament, but the judiciary should not become the final unchecked authority. Neither parliament nor the judiciary should be the supreme. The constitutional must be supreme through the balance and checks. That's the duty of judiciary, not the excessive and unchecked use of powers. That's my point.
I didn't get my answer, but okay.
Well, the time is over and he has answered at his own convenience. I would like to call CADC 30 for the motion.
Yes, sir. I am ready.
You may start your deliberation.
Just a minute, sir. Honorable, honorable chief guest, and all of my colleague participants. Today's debate topic is whether the judiciary should have power power of judicial review or not. I am uh, I am arguing in the for the motion in this stand. Basically, judicial review is a power to the court to review the laws made by legislature and actions which are taken by the executive. We all know, as per the Court of Lord Actons, power tends to corrupt, and absolutely power corrupts absolutely. Absolutely power एब्सोल्युटली पावर नहीं होना चाहिए लेजिस्लेचर से इसके लिए इसके इसी वजह से जुडिशियल रिव्यू का कंसेप्ट लाया गया था जो जुडिशियल रिव्यू का कंसेप्ट है वो फर्स्ट यूएसए में था उसके बाद उसको अडॉप्ट किया इंडिया ने सो एज वी नो जैसे कि अगर डेमोक्रेसी रखनी है तो जुडिशियल रिव्यू होना जरूरी है कोई भी लॉ हो अगर उसे जज ही नहीं किया जाएगा तो कैसे पता चलेगा कि वो गलत है या सही है कोई कोई तो देखने वाला चाहिए जो बता सके कि आपका कार्य गलत है या सही है वो बताने के लिए कोर्ट एज ए जुडिशियल रिव्यू से एक्ट को अनकॉन्स्टिट्यूशनल डिक्लेयर करता है या फिर कॉन्स्टिट्यूशनलिटी डिक्लेयर करता है एक्ट की जैसे कि इंडिया इज अ डेमोक्रेटिक कंट्री सो democracy is the country of the people so people have power to raise their voices and their issues against the acts made by the parliament or legislature so uh, people directly can approach to the supreme court under the article 32 of the constitution which gives power to judicial review to the courts as before the pre-independence era there was a few cases and some judgments which shows that the judicial reviews actions by the courts in the Emperor versus Bura case held that court could examine the whether legislature exceed legal authority. In the Annie Besant versus Government of Madras, Government High Court examined that executive actions and legality of detention order. In this case, held that executive actions can be determined by the court in the High Court. This case was held in 1980s. This is related to Defense of India Act 1955. Under this act, Annie Besant was detained in recentral provinces and Bear Act. Federal Court examined legislation violated distribution of power under the Government of India Act 1935. Courts could invalidate laws beyond the legislative component. It was held in this case. Government of India Act established federal courts in 1937. Court gain authority to determine whether legislature exceed constitutional limits or not. Became direct constitutional predecessor of judicial review and in independent India. B.R. Ambedkar were a strongly supporter of judicial review. Believe that courts must protect fundamental rights of rights of people of India and citizens against the legislative and executive abuse. Article 30, as they say, Article 32, the soul of Constitution and very heart of it. Judiciary should act as a guardian of the Constitution. Judiciary should protect the Constitution and interest of the citizens of India. So, by the principle of judicial review, Supreme Court, High Courts, and or other uh, courts protect interest of the citizens of India, and as a constitutional amendments and constitutions as is a sovereign authority. So supremacy of the constitution. If the judicial review does not exist, then constitution can be amended by anyone, and absolute power corrupts absolutely. जैसे कि पहले हम ब्रिटिश रूल के अंडर थे, तो उस टाइम पे हम गुलाम बन के रह रहे थे. वैसे ही अगर पॉलिटिकल एब्सोल्यूट पावर आ जाती पॉलिटिकल पार्टीज के पास या फिर कुछ लोगों के पास, तो उनको सही या गलत जो वो कार्य कर रहे हैं वो उनको सही ही लगता. कभी भी अगर उसको कोई बताने वाला नहीं है कि ये आपने पास किया हुआ एक्ट गलत है, तो उनके कार्य उनको सही लगते हैं और इसी वजह से हम फिर से उनके गुलाम बन के रह जाते. जैसे हम डेमोक्रेटिक कंट्री में सिटीजन्स को बचाने के लिए और कॉन्स्टिट्यूशन को बचाने के लिए जुडिशियल रिव्यू हेल्प करता है. जुडिशियल रिव्यू को स्ट्रांगली सपोर्ट किया था लीडर्स लाइक बी आर अम्बेडकर, आल्लादी कृष्णा स्वामी अय्यर, के एम मुंशी. Strongly defended judicial review, which ultimately become cornerstone of the Indian Constitution. Indian Constitution and is judicial review help to protection of the fundamental rights and prevention of absolute power. Constitution must be supreme, so that helps to supremacy of the Constitution and rule of law. It protects rule of law. It's ensures that check and balance theory in the Indian legislative and Indian government. Check and balance theory. By applying check and balance theory, is Indian courts and Indian courts Indian courts use judicial reviews, and thank you. No more.
CADC 29.
Yes, may I start?
Yes, please start.
Honorable members, I want to start with some very good news. In this great democracy of ours, you can vote. You can elect your leaders can make laws, and the president can sign them. And then the exciting part, a group of people that nobody voted for can look at all of that and say, no, that's it. No appeal, no election, no way to say, excuse me, sir or madam, we disagree. We call this judicial review, the other side calls it safeguard, and I call it something else. And by the time I finish, I think you will too. माननीय सभापति महोदय, जिस देश में जनता वोट देती है अपना भविष्य चुनने के लिए, उस देश में यदि एक अनिर्वाचित संस्था जनता के निर्णय को पलट सके, तो प्रश्न ये नहीं है कि संस्था सही है या गलत. प्रश्न ये है कि वो शक्ति आई कहां से. ये प्रश्न केवल कानून का नहीं, ये प्रश्न लोकतंत्र की आत्मा का है. Now, I want you all to picture a cricket match, okay, where everything is going well and suddenly the umpire stops the game mid-match and changes the rules. Not because anyone broke them, but because he felt like it. Would you call that cricket? I personally would call that umpire forgetting his place, and that is exactly what judicial review does. Now, tell me, you voted, right? You were the one who went to the booth, pressed the button, chose your MP, your MLA, someone who has to come back to you after 5 years and explain what they did. Now tell me, did you ever vote for a judge? Did anyone in any village, any town, or any city of this country get to pick those 5 people who will sit on a bench and decide whether a law lives or dies? As of 2024, the Supreme Court of India has struck down over 150 laws passed by the Parliament and state legislature since independence. And that is 150 times that unelected judges overruled elected representatives. And in not one of those 150 cases did anyone get to vote on that decision. नहीं, किसी ने नहीं चुना उन्हें, फिर भी उनके पास सबसे बड़ी ताकत है जनता के बनाए कानून को खत्म करने की. ये लोकतंत्र है या शक्ति का माया जाल? Judicial review gives unelected judges the power to throw out laws made by elected people. If a judge gets it wrong, you cannot vote him out. His decision stands. You cannot protest outside his house and change his mind. That is not a check on power. That is power without responsibility. The other side will say, if there's no judicial review, Parliament will do anything. With all due respect, ladies and gentlemen, saying that is like saying, if we don't put a lock on the lock will break. We already have checks. We have 2 houses of Parliament. Article 79 of our Constitution establishes this very bicameral system where no single house can ram through a law alone. We have a president who must give assent, and under Article 111, he can send a bill back. We have elections every 5 years, a free pass, and a civil society. Article 13 of the Constitution already says that any law which takes away the fundamental rights is void. Parliament itself is bound by this. The Constitution already has a self-correcting system built in without needing 5 judges to be the final word on everything. A democracy does not need one all-powerful judge sitting above everyone else. It needs its people to be awake, and in India, people are very much awake. Adding judicial review on top of this does not add safety. It adds one more person with power. A person who nobody chose, a person nobody can remove. Now, let me tell you about Ramesh. Okay, he lives in a small colony, and every night stray cattle blocks the main road. People have accidents, kids can't walk to school, and old people are even scared to step out. Ramesh goes to his ward councillor, as he should, and the councillor raises it. The state government debates it for months. They pass a law. The land will be taken, the shelter will be built, and the road will be safe. Everyone is happy. Finally, someone listens. And then a petition arrives. A judge sitting far, far away says the land acquisition touches on Article 300A, the right to property. He strikes the law down. The cattle are still there. The shelter is never built, and Ramesh still dodges them every night. The councillor loses the next election. The judge goes home safe. Nobody asks him anything, and nobody can. You tell me, in that story, whose vote matter and whose didn't? न्यायाधीश इंसान है, वो भी गलती करते हैं. फर्क बस यही है कि नेता की गलती पर हम उसे हटा सकते हैं, लेकिन जज की गलती पर हम बस खड़े देखते रह जाते हैं. As of 2023, India has over 5 crore pending cases in its court. The Supreme Court alone has a backlog of 80,000 cases. I repeat, 80,000 cases, and yet this same judiciary, which cannot keep up with the cases in front of it, is being asked to be the final guardian and final interpreter of this parliament. Is that realistic? Is that fair to the courts or to the people? And then the most important thing, the basic structure doctrine the other side loves so much. It is not written in the Constitution, not one word. Not in Article 368, which deals with constitutional amendments, not anywhere. The judges invented it in Keshav Nanda Bharati and state of Kerala in 1973. They created a rule to protect their own power and now use that rule to strike down laws passed by people. That is not protecting Constitution, that is rewriting it, quietly without a single vote. I want to be very clear. I'm not saying Parliament should do whatever it wants. I'm not saying rights don't matter. I'm saying the way we protect rights must be democratic. It should not involve people. It should involve people, not just courts. The United Kingdom has no judicial review over Parliament. Parliament is supreme, and Britain has one of the strongest human rights record in the world. So when they say rights will die without judicial review, tell them to look at Westminster. By all means, keep judicial review, let 5 judges override the mandate of 140 crore people, and then go back to Ramesh and look him in the eye and say, your counselor tried, your MLA tried, your parliament tried. But a judge sitting far, far away read a petition, so the cattle will stay. Who watches the people? Who watch everyone? Nobody. And that, honorable members, is not a feature of this system. That is its greatest flaw. हम न्याय के खिलाफ नहीं है, हम उस शक्ति के खिलाफ है जिसका कोई पता नहीं, कोई चेहरा नहीं और कोई जवाबदेही नहीं. Jai Hind, Jai Bharat. I'm open to questions and I would like to begin with the reporter.
CAGC 30, do you want to exercise a rebuttal?
Yes.
Okay.
Your time starts now.
Yeah. You said that you don't trust parliament elected by millions, but you can trust 5 people.
Ma'am, CADC 30 would like to exercise a rebuttal at first.
Okay, all right, sure.
Yes. As the CADC 29 said, politicians are have rights to make laws, and politicians are elected by the peoples of India, and judges are not elected by the peoples of India. I want to just say, democracy without education is hypocrisy without limitations, which is said by leaders, Ram Jethmalani. So I want to just say that judges are educated enough to give decisions on the laws made by the parliamentarians and members of the Lok Sabha and Rajya Sabha. So they are those members are not that much education have that much education to make laws, and अगर वो पढ़े लिखे होते तो वो खुद अच्छे से लॉज बना पाते, और अच्छे से अगर पीपल के बेनिफिट में लॉज बना सकते थे तो जजेस को जुडिशियल रिव्यू देने का कुछ सोर्स ही नहीं बचता, अगर ट्रांसपेरेंसी रहती और अकाउंटेबिलिटी रहती उतनी तो. और एक कहना था मुझे कि आपने जैसे कहा था कि पीपल्स से इलेक्टेड होते हैं वो लोग, तो और भी बहुत सारे मेंबर्स है जो पीपल से इलेक्टेड होते हैं और उनको भी अच्छे अच्छे लॉज बनाने होते हैं, बट बिकॉज ऑफ दी जो उधर मेजोरिटी लगती है वो मेजोरिटी पूरी नहीं होती, उसी वजह से लॉज वगैरह नहीं बनाए जाते. उसके लिए PIL वगैरह फाइल कर सकते हैं, पब्लिक इंटरेस्ट लिटिगेशंस, लोग उससे जुडिशियल रिव्यू के लिए जा सकते हैं. तो ये अच्छी बात है ना, अगर पीपल्स डायरेक्टली अप्रोच कर सकते हैं कोर्ट को. तो इस पे आपका क्या ओपिनियन है भाई?
Okay. Over is your time. CADC 29, your time starts now.
Should I answer them?
Yes, ma'am.
Okay, so आपने अभी बोला कि जितने भी हमारे पार्लियामेंट में लोग हैं वो अनएजुकेटेड है, आपने बेसिकली ये बोला. सो व्हाट डू यू थिंक जो हमारे सिटीजन्स हैं, जो इंडिया के लोग हैं, वो लोग इतने अनवाइज हैं अपने सिलेक्शन के लिए जब वो लोग वोटिंग कर रहे हैं? अगर ऐसा है कि हम हमारे जो पार्लियामेंटेरियंस हैं उन्हें अकाउंटेबल ही नहीं समझ रहे, तो हम वोटिंग क्यों रख रहे हैं? फिर वोटिंग ही नहीं करनी चाहिए इस हिसाब से. अगर हम वोटिंग कर रहे हैं तो जो हमारे पार्लियामेंट में लोग हैं हमें उन पे एटलीस्ट ट्रस्ट तो करना चाहिए, बिकॉज दे आर ऑलरेडी बाउंडेड बाय कॉन्स्टिट्यूशन. The judges, nobody elected those judges. And what would you like to say about the 5 crore pending cases in the court? What about those 80,000 cases pending in Supreme Court? Those 80,000 PILs which you're talking about?
Should I answer?
Yeah.
So ये जो केसेस के बारे में आपने कहा, वो केसेस के बारे में जो केसेस पेंडिंग है वो केसेस ट्रांसफर की वजह से पेंडिंग है. जो ट्रांसफर ऑफ जजेस होते हैं वो ट्रांसफर ऑफ जजेस भी पॉलिटिशियंस की तरफ से ज्यादा करके किए जाते हैं. ये भी मेरा पॉइंट रहेगा. मैं ज्यादा पॉलिटिक्स की बातें नहीं करना चाहूंगा, लेकिन एक वो भी है कि पॉलिटिशियन की वजह से 2-2 महीने में 3-3 महीने में ट्रांसफर होते हैं जजेस. जब जजेस ट्रांसफर होते हैं तो उनको हर एक केस स्टार्टिंग से इंटरप्रेट करनी पड़ती है एडवोकेट को. जब सामने केस आएगी उस टाइम पे तो उधर से अंडरस्टैंडिंग लेके केस लेनी पड़ती है आगे जज को. तो कैसे जजेस डिसाइड कर पाएंगे केसेस जो है सामने वो. और जजेस की जो कोर्ट्स है वो कोर्ट्स भी कम है, पॉपुलेशन बढ़ती जा रही है तो जजेस की रिक्वायरमेंट भी बढ़नी चाहिए, जजेस भी और ज्यादा अपॉइंटमेंट करने चाहिए केसेस के हिसाब से. But
बट अगर अभी जो हम रिसेंट वाला केस ले जहाँ पे सुप्रीम कोर्ट में एक कोई तो आई गेस 5th स्टैंडर्ड की बुक थी जिसमें जुडिशरी के बारे में कुछ लिखा हुआ था which was
ADC
opposing them.
29.
Yeah.
We have already exceeded the 2 minutes time.
Okay, thank you, sir.
Okay.
Now I would like to call CADC 32 for the motion.
Yeah. With your chair's permission, I would like to proceed with my points.
Your time starts now.
Honorable Chair and esteemed members of this family, esteemed members of this assembly, today we have gathered एक ऐसे topic पर बात करने हैं, that is whether judiciary should be entrusted with judicial review or not. इससे पहले हमें ये समझने की बात है कि judicial review जो है, it is not merely a technical provision. This is that provision of the constitution जो हमारे रिपब्लिक के कैरेक्टर को डिफाइन करेगा अगले 300-500 साल तक. अब हमारे आगे क्वेश्चन ये है कि क्या हम एक ऐसा कॉन्स्टिट्यूशन बना रहे हैं जो सिर्फ राइट्स देता है, और आर वी क्रिएटिंग समथिंग जो राइट्स को लिमिट भी करेगा. एट द फर्स्ट आउटसेट ऑफ दिस इशू, जुडिशियल रिव्यू जो है, इट इज नॉट एन एक्स्ट्रॉर्डिनरी और अ रेडिकल आइडिया. हर देश में सुप्रीम लॉ ऑफ द लैंड होता है, विद इन करेस्पॉन्डेंस कोर्ट्स भी होते हैं जिनका फंक्शन होता है कि लाइक दिस पीपल लाइक interpret the laws, see everything is in accordance with the laws. Therefore, it is a very important authority. अभी हम जो आज एक कॉन्स्टिट्यूशन बनाने की बात कर रहे हैं, even we require an authority as such. अगर एक ऐसी अथॉरिटी नहीं है that is overlooking the supreme law of the land, फिर हमारा कॉन्स्टिट्यूशन सिर्फ एक mere guidelines बनेगा and it will never be supreme law of the land. अब इसका ऑल्टरनेटिव भी मान लेते हैं कि अगर आज असेंबली ने जुडिशियल रिव्यू इंप्लीमेंट करने से मना कर दिया, फिर अल्टीमेटली अथॉरिटी जाएगी लेजिस्लेचर के पास. बट इज लेजिस्लेचर एक्चुअली केपेबल ऑफ डूइंग समथिंग ऑफ दिस सॉर्ट? अभी लेजिस्लेचर जो है, इट इज अ पॉलिटिकल बॉडी, इट इज इलेक्टेड बाय पीपल, तो इनके ऊपर वो एक्चुअली दबाव होता है कि टू एक्चुअली प्लीज दिस पीपल, ताकि अगली बार भी तो इलेक्शंस भी जीतने होते हैं. So they are immune and they are prone to make mistakes and errors. अगर हम पार्लियामेंट्री सॉवरेनिटी और पार्लियामेंट की एब्सोल्यूट को अगर हम पास कर देते हैं, then there is no reason for a constituent assembly to be sitting to bring about a constitution which will never be useful. अभी जुडिशियल रिव्यू का ट्रेडिशनल नोशन ये रहा है कि सुप्रीम कोर्ट एंड अदर कोर्ट्स जो होते हैं, these are basically watchdogs जो laws को देखते हैं, they see whether everything is in compliance with the supreme law of the land or not. मैं एक ऐसा justification देना चाहता हूँ कि judicial review जो है, it is closely interconnected with the fundamental right of right to be heard. अभी जब कोई state एक ऐसा law लाता है that is infringing certain people's fundamental rights, that individual can through Article 32 or 226 can approach the court and seek sufficient remedies which he requires. Coming to the parallel of this, अगर ये legislature के पास power vest होगी, so it is practically impossible that legislature can accommodate all these cases. हर बंदा legislature के पास जाकर हाथ ये नहीं कर सकता कि मेरा ये नुकसान हुआ है कि you need to provide me this. It's practically not possible. So it is only judiciary जो एक non-partisan body बनकर actually ये benefits दे सकती है. अभी कुछ लोग कहेंगे कि this is undemocratic क्योंकि judges लोग actually elected नहीं. अभी ये होता है कि दिस इज बेसिकली मिसअंडरस्टैंडिंग ऑफ डेमोक्रेसी. अभी ये समझने की बात है कि अभी डेमोक्रेसी जो होती है, दैट इज बेसिकली बाय द पीपल, ऑफ द पीपल एंड फॉर द पीपल एज वी नो. तो ये बात ये भी होती है कि वी नीड टू प्रोटेक्ट द डिग्निटी राइट्स ऑफ एवरी इंडिविजुअल आउट देयर. इट इज नॉट अ कलेक्टिव डिसीजन मेकिंग बॉडी, बट रादर वी आर प्रोटेक्टिंग ईच वन एंड ब्रिंगिंग ईच वन ऑफ देम विद इन द एम्बिट ऑफ जुडिशियल. सबको बचाने की, सबके अधिकारों का रेस्पेक्ट करने के लिए हम ये जुडिशियल रिव्यू ला रहे हैं. Therefore, ये right to hearing जो होता है, it is strengthening democracy, it is deepening the very essence of democracy, the constitution and ultimately the country. आज हम एक कॉन्स्टिट्यूशन बना रहे हैं not to build a perfect society. एक आइडियल समाज बनाने के लिए हम कॉन्स्टिट्यूशन नहीं बना, हम कॉन्स्टिट्यूशन एक ऐसी चीज के लिए बना रहे हैं कि आगे जाकर जब कोई गलती हो जाती, सरकार की वजह से, सिटीजन्स की वजह से, जब भी कोई गलती हो जाती, वी हैव अ प्रॉपर लॉ, हमें पता है कि क्या करना है इस वक्त पर. इसीलिए हमें कॉन्स्टिट्यूशन चाहिए. अगर ये नहीं होगा तो सब गिर पड़ेगा. सो हम सिर्फ
उनके विजडम पर रिलाई नहीं कर सकते जो सिर्फ पावर पर है। Therefore, अगर हम सच में जस्टिस, अकाउंटेबिलिटी, गवर्नेंस, ऑल दिस कॉन्स्टिट्यूशनल प्रिंसिपल्स के ऊपर एम्फोसिस कर रहे हैं, तो हमारा महत्व यहाँ भी जाना चाहिए कि सिटीजन्स के पास सिर्फ राइट्स ही नहीं दिया जा सकता, उनके पास ऐसे हथियार भी दिया जाना चाहिए जो इस चीज से वो अपने राइट्स को डिफेंड कर सके, प्रोटेक्ट कर सके और क्वेश्चन कर सके जब उनके ऊपर वो दबाव आता है। अल्टीमेटली मैं इसमें कहना चाहता हूँ कि अगर संविधान के पास जुडिशियल रिव्यू का पावर नहीं है तो कॉन्स्टिट्यूशन सिर्फ इरादों का बयान ही रहेगा और कभी हमारे अधिकारों का रक्षक नहीं बन सकता। थैंक यू।
CADC 31, CADC 31, CADC 31. In wake of his unavailability, we'll be proceeding further with the CADC 34 and 33. CADC 34, CADC 34, CADC 34.
Yes, sir.
Okay. Your time starts now.
I'm not audible.
You're audible. You're audible. CADC 34, your time has started.
Yes, sir. Respected judges and honorable opponents, my dear friends, I stand with you to firmly support the notion that the judiciary must have the power of judicial review. At its heart, judicial review is the authority of courts to examine laws and government action and invalidate them. If it violates the Constitution, it is not extra privilege given to
CADC 34, you're not audible properly. You may restart your
It is
connection.
unnecessary.
Meanwhile, we'll be
Okay.
Meanwhile, we'll be starting with CADC 33. CADC 33. CADC 33. CADC 33, it is your last call. CADC 33. Due to his non-responsiveness, we'll proceed further. CADC 35. CADC 35. CADC 35. CADC 36. CADC 36. CADC 36. At the discretion of the Honorable Chair, ma'am, you may mark them as absent. Whereby, we'll be waiting just for a minute for CADC 34 to rejoin. And we'll be just waiting for 2 minutes for his arrival. If he has come within 2 minutes, so we'll be continuing with him, or rest we'll be ending the session.
Moderator, I think CADC 34 is in the meeting. Can you please call him out for once?
CADC
Hi, it is
34.
at participant number 33.
Uh, we have called you thrice. What's CADC 33?
I was stuck in a situation, so wasn't able to respond.
Okay, you may respond after CADC 30, 33, 34. I'm sorry. CADC 34.
Okay, thanks.
CADC 34.
Yes, sir.
You may
Respected
start.
judges, मैं start करूं?
हाँ जी, आप please start कीजिए.
Respected judges, honorable opponents, and my dear friends, I stand before you to firmly support the motion that the judiciary must have the power of judicial review. At its heart, judicial review is the authority of the courts to examine law and government action and invalidate them if they violate the constitution. It is not extra privilege given to judges. It is a necessary safeguard built into a constitutional democracy. Power is safest only when it is answerable, and judicial review is the mechanism that makes even organ of the state answerable to the constitution. Without it, the idea of limited government collapse and right becomes uncertain promises. Democracy is often described as the rule of the majority, but a mature democracy is much more than number. It is a system where the majority governs with constitutional limits and where the rights of minorities and individuals are protected. The Constitution of India is supreme and every authority, legislative, executive or judicial, derives from its power. Judicial review ensures that its democracy. Judicial review ensures that this supremacy is real, not symbolic. When law cross constitutional boundaries, courts have both the authority and duty to intervene. A constitution without enforcement is merely judicial review if give it life. In India, the power is not vague or implied. It is clearly anchored. The Constitution, Article 32 and 226 provide the right to approach the Supreme Court and High Court respectively for the enforcement of fundamental rights. These articles empower the courts to issue writs such as habeas corpus, prohibition, certiorari, and covenantum. Dr. B.R. Ambedkar called the heart and soul of the Constitution. To Together, these provisions make judicial review a living reality, ensuring that citizens are not left helpless against unlawful state action. The importance of judicial review becomes even clearer when we look at landmark constitutional cases. One of the most significant them is Keshwanand Bharati case is versus state of Kerala. In this historic movement, judgment, the Supreme Court addressed as a crucial question: can Parliament amend any part of the Constitution without any limitation? The court held that while Parliament has wide powers to amend the Constitution under Article 368, it cannot alter its basic structure. These include essential features like the rule, separation. जैसा कि आप सभी लोग जानते हैं कि केशवानंद भारती केस वर्सेस स्टेट ऑफ केरला में सुप्रीम कोर्ट ने अपना जो जजमेंट था वो उसने एक डिफाइन वो भी करा था बेसिक स्ट्रक्चर डॉक्ट्राइन जो कि इंश्योर करता है हम लोगों के राइट्स को चेक और बैलेंस को जो कि जरूरी था। एक मैं केस को लेना चाहूंगा एग्जांपल में जो कि शायरा बानो वर्सेस यूनियन ऑफ इंडिया का कॉमनली नोन एज द ट्रिपल तलाक केस जिसमें कि ये प्रैक्टिस होती थी मुस्लिम वुमेन और मुस्लिम मेंस के बीच में जिसमें कि मुस्लिम मैन 3 बार तलाक तलाक बोल करके मैरिज को एंड करने की बात करते थे। डिवोर्स एक तरीके से उनके कल्चरल राइट्स में देते थे जो कि मुस्लिम वुमेन्स के लिए उनकी डिग्निटी को उनके राइट्स को हर्ट करता था इन अंडर द आर्टिकल 14, 15 and 21 which guarantee equality, non-discrimination and the right to life and dignity. The court declared instant triple talaq unconstitutional, holding that it violated the basic principles of equality and justice. Tradition cannot be a justification for injustice. Through judicial review, the court ensured that personal laws and social practices are also subject to constitutional values. That
Yes,
this
DC.
decision.
34, you have exceeded your time.
Okay, sir. Sir, 2 minutes, please.
No, sir, we are not provision for any extension.
Okay.
CADC 33. CADC 33.
I would like to ask about a clarification question.
Yes, sir.
Are we to rely solely on the as constitutional issued on 26 January 1950, or we can take discuss later developments?
So you need to stick to the timelines.
Up to 26 January 1950.
Oh, yes, sir.
So
Your time has
as my
already started.
okay. So as my peers have purposively argued about the power of judicial review should exist and should be exercised by courts, my approach is slightly different. It is not clearly a absolutist stance that judicial review should not exist. Neither it is a completely favorable stance. It is a middle ground, which largely relies on the doctrine of restraint. Judicial bodies are meant to exercise restraint in their judicial function. Although constitutional debates empowered the judges, courts to for the purpose of judicial review, fundamentally for the purpose of enforcement of fundamental rights as contained in Part 3. The judicial review doctrine was limited to only that. It was not meant to be extended in other spheres of policy decisions or other matters. As we are aware, as Constitution stood on 26 January 1950, we have in our Constitution under Part 3, Article 13, Article 32, and Article 226. All these 3 articles are fundamentally concerned with judicial review is meant to be exercised only when there is a violation of individual fundamental rights. It is to be not exercised in mere policy decision, or it is not to be exercised in cases where we consider that the legislature has executed a bad law or passed a bad law. Bad law is a different issue. Violation of fundamental rights is a different issue. So, in Constituent Assembly, when we envisioned about a judicial review, it was fundamentally for the enforcement of fundamental rights. It does not cross their minds that judicial review can be extended in other spheres. Because they thought that there is we are envisioning separation of powers in our constitutional. We are separating executive, legislature, and judiciary. So all these three organs should exercise restraint and not encroaching sphere of other. But these concerns were often, I guess, it is a constraint of time or a lack of foresight that they could not see that in future the situation might turn. That we are trying to in Constituent Assembly we are trying to protect the rights of individual fundamental rights, but maybe this power can be expanded unilaterally and maybe can be used to encroach in rights of legislature and executive. So this is the reason I am contending that judicial review cannot be absolute. It has to be limited. It has to be extremely restrained in action in its provisions. If we take from where judicial review doctrine comes, it comes from a US Supreme Court case known as Marbury v. Madison. US Constitution does not ingrain the judicial review doctrine. It is largely a judicially created doctrine. It has no constitutional basis or statutory basis in Constitution of United States. So when courts in United States exercise power of judicial review, they are extremely restrained in their actions. They do not unilaterally strike down laws or provisions because somehow they are considered to be bad laws. They have to be inconsistent with the rights of fundamental rights of individual rights in the person of the United States. The ground from a judicial review cannot be that because legislature passed a law which kind of decreased the power of judges or shifted the jurisdiction of court. It cannot be a means of judicial review. Judicial review, if we go back to the Marbury versus Madison case, it was fundamentally envisioned and as integrated in our own part 3 of the Constitution, that is Article 13, Article 32, Article 226. These from the pioneer case of United States Court and from our own Constitution. This is primarily and fundamentally meant to preserve and enforce the fundamental rights of the people. Judicial review is merely that. It cannot be anything more than that. After that, if anything, that any encroachment over that is the courts acting as a pseudo legislature. I repeat, a pseudo legislature body pretends to act as a legislature without having any legitimacy to act as a legislature. It is not elected by people. It does not answer to people. It is a permanent body. It is antithetical to very democratic principle of universal adult suffrage and electoral rolls of all. So therefore, the judicial review has to be restrained and toned down. There has to be explicit safeguards that to what extent judicial review can be exercised. It cannot go arbitrarily. Doesn't matter how bad people consider to be a legislature is, how poor it is drafted. It can be exercised only when it is in violation of Part 3, as it is today. Part 3 is our fundamental right. It violates Article 14, Article 15, Article 17, 18, 19, 21, so on to up to 30. So only these grounds are the legitimate grounds for exercise of judicial review.
We have already exceeded the time. CADC 34, would you like to exercise a rebuttal? CADC 34, would you like to exercise a rebuttal? CADC 34, would you like to exercise a rebuttal?
No, sir.
Okay. Well, thank you. CADC 33, would you like to exercise a rebuttal? CADC 33, would you like to exercise a rebuttal?
I would like to exercise. He discussed the case on Bharati case. I would like to rebut some points of it.
Sir, you have 1 minute of rebuttal.
Yeah. See, basic structure doctrine is a legal fiction. Legal fiction is only sustained only up to the extent it is used to enforce the right of people, protect the right of people, enforce their fundamental right. It cannot be used as a means to encroach in powers of legislature or powers of executive. Today, basic structure doctrine is used to solely micromanage the executive policy, micromanage the legislative affair. Recently, in Madras High Court Bar Association versus of Union of India case, the Supreme Court struck down the Tribunals Act. The Tribunals Act, striking down Tribunal Act was a purely unconstitutional measure. Court justified it on basis of a separation of powers, independence of judiciary. But tribunals are not a judiciary body; they are quasi-judicial body. They function on executory method. Irrespective of that, they rely on a judicial power. Their process and procedures are entirely administrative in nature, even though they exercise judicial power in respect to judgments. What was court managing there? It was micromanaging that tenure should be 5 years. It should not be 4 years. The age of advocates to be nominated in tribunal could not be less than 50 years. It can be only up to above 50 years. So see, is it a fair exercise of judicial rule? No, it is judicial power grab of the legislature and executory power. It is nothing more than court acting as a pseudo legislature. It is pretending to be what it is not. Neither constitution empowers it, nor people have empowered it. Nor part 3 empower it, nor other any constitutional provision empowers it. Thank you.
We have already exceeded the time. Thank you so much. Thank you so much to the Honorable Judge, Ma'am Ms. Niti Kaswar, and all the participants who have spared the time for this enlightenment debate. Respected Judge, esteemed faculty members, and my dear participants, on behalf of the MIT Law School, MIT University, Madhya Pradesh, I extend my gratitude to all of you for contributing to the successful conduct of this preliminary session of the National Level Constituent Assembly Debate Competition. We would like to especially thanks to our Honorable Judge, Ms. Nidhi Kaswar, for her valuable time and insightful evaluation. We would like to convey our deep regard to Honorable Pro Chancellor, Lieutenant General V.K. Sharma, AVSM, Honorable Vice Chancellor, Professor R.S. Tomar, Sir Major General Rajinder Kumar, AVSM, SM, VSM, Director, MIT Law School, MIT University, Madhya Pradesh, faculty members, and organizers for their constant support and guidance. A heartfelt appreciation to all the participants for their enthusiasm, thoughtful arguments, and excellent articulation on such a significant constitutional topic. We also convey thanks to the Law Octopus as it is our promotional partner. Lastly, we thank the organizing and technical teams for ensuring the smooth execution of the session. With this, we conclude the preliminary round and look forward to the next stage. Thank you. Ma'am, would you like to extend some enlightenment?
No, I just want to thank you all for inviting me, first of all. And second of all, I'm impressed with everyone. Everyone has given their own perspective of, for and against judicial review. And I want to just say that best of luck to all the participants for your future and do well. That's all.
Thank you so much, ma'am. Thank you so much for the wisdom words. And with this, we'll be concluding the session. Thank you so much for your time.
Excuse me, sir. Sir,
Yes, sir.
I had a doubt.
Yes,
Sir, I had a doubt that will we be informed that if we qualified for the next round, and if yes, then when?
Sir, within the next 2 hours, you'll be informed about it. And I'll once again confirm with the organizing team. But you'll be informed very soon.
Okay, sir. Thank you.